In 3, 2, 1.
And good afternoon, ladies and gentlemen. Welcome to the Board of County Commissioners Superior Court update for Thursday, December 3rd, 2020. Are phone calls set up for conference calling, Amy or Megan?
Yes.
Okay, if you'd like to call in and listen, not public comment, but listen, the phone number is 360-252-9020, and the PIN number is 1234. I'm John Hutchings, the chair of the board, and we also have Vice Chair Commissioner Ty Menser. Commissioner Gary Edwards may call in, we're not sure, but we also have the Assistant County Manager present, Robin Campbell, and we have Presiding Judge Eric Price, and we have the Pam Hartman-Beyer, the Clerk of the Court, or Administrative. Pam, what's your title? Your
Superior Court Administrator.
Thank you, ma'am. Thank you. And so we're going to be doing a Superior Court update. And so, Judge, why don't you start if you're ready?
All right. Well, thank you, Commissioner. The main issue I wanted to update the board on was the decision that we took last week as a Superior Court to suspend jury trials as a result of the increasingly worse numbers on our county, the pandemic. The chronology of this decision took place over about a 10-day period. We have been in regular contact with the county health department regarding our operations and our decision to be doing jury trials. We had been doing jury trials since, I'm trying to remember when we started up. We started up initially in July 6th. Then we paused again, and then we started up again. I don't have that. Maybe Pam has those numbers. But we have been doing jury trials, or been available to do jury trials, with a number of trials being set for 5-6 weeks. We had, as the numbers were getting worse in our county, we had one eye kind of open to that and wondering whether we should be entertaining a change in that, knowing that what a jury trial entails is bringing people through a mandatory summons to potentially respond to jury duty, and then take those people into the courthouse and then select a jury from them. We had obviously been working with county health throughout the process to, as well as our, the own guidance provided through the state courts and our Supreme Court, to have that process work as safely as possible, to require masking, to have distancing, to really limit the number of potential jurors coming into the courthouse. We have talked before in our updates to the commission about how we only had the ability to do one trial instead of 4 because of our physical plant here, and we had discussed an offsite space which has been being developed. But we had just one trial that was going per week. We had been in contact with county health even earlier, I think, in the week of November 9th. That's when this really started, November 9th. And the guidance we received at that time, at least informally, was, don't stop anything you're doing now, but things are not looking great. Towards the middle of that week, the week of November 9th into the end of that week, we had a discussion, a request from county health to have a discussion with us to outline their concerns with the increasingly bad numbers in the county, and their concern with court operations, but specifically with jury trials. So we had that discussion with county health, both Dr. Abdul-Malik and Shelley Slaughter, on November 13, and the end of the day, and got preliminary advice from them to really pause our jury trials. We had a jury trial that was targeted to start on the 16th. That was actually moved to be continued by the parties for the pandemic reasons. That motion was granted. In the meantime, we were waiting for a more detailed written guidance from county health to support what they had told us orally. We received that at the end of that week on the 20th, and then turned around at the end of the day on the 20th. And then on November 23rd, which was that following Monday, we issued an emergency order number 7, which outlined the governor's emergency shutdown that had occurred, and then the Supreme Court's cautionary orders, as well as attaching the written guidance we received from County Health, recommending that under the circumstances, we should be pausing jury trial. So that order went out on the 23rd of November, which was important because we had a number of trials on what we call our jury or a trial confirmation calendar set for that next Tuesday, the next day on the 24th. We ended up continuing all those trials. And some of, to be honest with you, some of the in-custody defendants are not happy with that decision. I certainly don't blame them for not being happy with the delay of their the right to a jury trial, particularly for our folks that are in custody. But based on that emergency order, we made that decision to postpone those trials. The order itself postpones or suspends trials at this point to January 19th. That's the Tuesday after Martin Luther King holiday. To be honest, we looked at the 11th as well, but based upon our understanding of the current guidance and and our discussions with Dr. A talking about sort of that 2-week lag from a potential spreader event to then when you see those numbers, we felt that another additional week past the New Year's holiday was a prudent choice. To be honest, that was a choice we made, although just today talking with both Dr. Abdulmalik and with Shelley Slaughter, they endorsed that day as being one that was prudent given the circumstances. We had, I should also mention this, I think I've mentioned it maybe offline to a couple of you, but I had been engaged in conversations with other presiding judges during this time period, as well as some groups convened by the Supreme Court. The Supreme Court, if you recall, the Supreme Court made a decision to have a statewide order that postponed jury trials back in March, and that order continued until July. There was some discussion about whether the Supreme Court would have another statewide order that in reflection of the deteriorating numbers across the state, and it also in consideration of the governor's change in his mandates. It became relatively evident that the Supreme Court was not necessarily going to take that approach. And also, to be candid, my discussions with some of the presiding judges, many of the counties were going to, at least indicated, and this is basically the week of the 16th, November 16th, that they were going to continue with trials, even some of the bigger counties. So, making the decision on a county basis was somewhat different from some counties. Snohomish County was going to cancel, but for example, Spokane County wasn't, Pierce County wasn't. Since that time, I'm happy to say that most, if not all of our sister counties have adopted the position we took to suspend jury trials. So I think just about most of the counties, and again, I don't have the updated numbers, King County, Pierce County are important counties for us, particularly Pierce County, because they're within our division. For them to take the same approach really reflects, it makes our decision, it just makes it a better decision for the purposes of appeal, for example, when these defendants are unhappy with not getting their jury trial. So anyway, that's a mouthful, that's a long recitation, but it's a big, significant step that we took. It was taken with a lot of deliberation, and certainly, and this is what I've told to countless defendants since I've been telling them, because I handle those trial confirmation calendars, and I'm delivering the news that their trial won't happen when they thought it was going to happen. To just tell them, we made the decision with the right to trial for these defendants at the forefront of our consideration, and we don't take the decision lightly. However, on balance, we have to balance that with the rights of the citizens of the county to not bring them into the courthouse for jury duty at this high risk time, knowing hopefully we have some light at the end of the tunnel coming in either hopefully January or if not in the spring. We did talk with County Health about when it would be likely to get some additional guidance on whether that January 19th date is reliable. Right now, it's our best estimate is when we can restart trials. That will have a lot to do with what the county numbers look like over the course of the month of December. And I think, we've got just two schools of thought. People will begin to learn some lessons from the increasing numbers and change some behaviors, or if they don't, we are where we are. So I'm happy to answer any questions about that.
Well, the short answer, or short comment I have is the MLK, or the day after that, Tuesday the 19th, as resuming rather. I think it was a brilliant strategic move. Very good move to go the extra week. I have some other stuff to ask, but I'll go to Ty first. Go ahead, Ty.
I don't have any questions. The judge brought this, explained this all to me on our one-on-one, but I guess for what it's worth, as you're considering what's reasonable, and of course I work for the public defense, so I care deeply about defendants' rights, but I came here from Alaska where we had a 120-day speedy trial, and we thought that was very aggressive and progressive because a lot of states don't have any such thing. And then I came to Washington, it was 90 days, and I was kind of blown away. Like, I've never seen a speedy trial right that aggressive. So I guess my point is just that if a health pandemic requires you to delay a trial by 1 month or 2 months, I think that's well within the bounds of reason, even for in custody. I mean, that's why we need to work on bail reform and make sure we're being very, very surgical about who needs to be detained pretrial and all of that. But I certainly don't see it as unreasonable at all, even though I have a very pro-defense perspective, just because the number of cases, and even at 120 days, it's usually felony cases, right? Those are the folks that are usually in custody in Washington anyway. That's not true in Alaska, but in Washington. And so I can count on one hand the number of cases in my whole career where that 120-day deadline really drove the bus. I mean, getting felony case, with a typical public defender caseload, getting a felony case ready for trial usually just took longer than that, even if your client was in custody. And clients work with their lawyers. I think you told me that the lawyers are doing a good job. You thought that the public defender was doing a really good job of working with their clients on understanding the considerations, and for the most part, they were agreed upon. So that's good, because the defense lawyers know it's like, there's very, very rare that's really your driving thing. Like, oh, we're going to get the trial in 90 days, because usually if you're going to trial, it means you have some. Usually, it means you have a good case. You have something to work with. And those mean the preparation level becomes deeper because there's more to work with. And the lawyer usually wants more than 90 days.
Yeah, well, and our rule is even worse than that. Well, to the extent you use the word worse, and I'm careful when I use that, but 60 days for in custody in Washington. So 90 days for out of custody, 60 days for in custody, which is a very, very aggressive rule for speedy trial. One of the things that we had to do within this order that suspended trials was also to suspend the running of speedy trial. And that's kind of what I was referring to in terms of when our sister counties made a similar decision, it makes that decision more defendable. We do have the order the authority from our Supreme Court to make that decision to toll the running of that speedy trial. But that just sort of had to go hand in hand with the decision to suspend trials. You mentioned public defense, and yeah, they have done a nice job, I think, where they can in terms of discussing with their clients the reasons for this decision. You're still going to have some defendants, and it's their right to strongly disagree with that, and so we've had to deal with that. We're still going to have a big mountain of cases that are going to be bulged up at the beginning of January, that middle of January, and that's just going to be something that will impact us going forward into February and March, and probably past that. But it just, I hate to use the cliche, but it is what it is.
The board, I think you heard, or maybe you didn't, but the board voted to fund an additional two FTEs for pretrial services, specifically deal with pre-charge diversions, specifically to try to respond to what you just described. So hopefully that helps.
Yeah, we had a meeting recently that involved stakeholders, to include the prosecutor's office and the public defense. And I think if there's a I hesitate to say anything has a silver lining with this disaster that is this pandemic, but I think there are some real things that the offices have done to sort of reduce jail population and to reimagine the way they look at charging cases and bringing cases and how they resolve cases that hopefully will have some long-term impacts on our criminal justice system in a way that deals with the massive population growth we've had, the lack of tracking of resources to meet that growth, and having the necessity to kind of rethink things while not at the same time compromising public safety. And that's really the balance, right? How do you, sure, you can let everybody out of jail, but what does that do to public safety? So there must be ways to be more imaginative. And I'm happy to say that I think all the offices, stakeholders, including law enforcement that I've talked to are very open, have been doing things currently, and are open to continuing those when we get out from underneath this.
I have a question, Judge. You mentioned you just issued the emergency order number 7. And this is I'm just curious. When you have counties in this state that are very small in population compared with Spokane or King County, do they have fewer orders? And King County must be on like order number 52 and other counties might be on order number 3, or is everybody pretty much on par?
Well, that's a great question. I can't speak. I haven't taken a look at what all the different counties are doing. I can tell you, I think King County is in the 50s.
Oh, no kidding.
No, I think you just sort of spitballed that really accurately, actually. I think different benches, that's one of the things. We've got a non-centralized court system in this state. Other states are different. Other states have a unified court system. There are real advantages to a unified court system, and there are some disadvantages to it. Some states across the country have converted from a non-unified to a unified, which has caused an enormous amount of problems in that transition. Yeah. But one of the downsides of a non-unified system is you do have sort of different approaches, and I think different benches in various places have had a different level of, do we really need to say this in an order, or is this more of a guidance? Can we do it all in one? So I can't speak to why King County has felt the need to have 50 some orders. But I like what we've done. We've really kind of had broad strokes, 5,000 foot level orders, and then pumped our website with hopefully updated information that gets into the weeds.
So I would think it'd be more local control, which makes sense to me. And I didn't know if OAC has, if they put out orders and dictate to the rest of the state or not.
Well, it hasn't been the Administrative Office of the Courts. It's been the Supreme Court. And the Supreme Court has issued a number of directives and orders to deal with the pandemic. As I mentioned earlier, they themselves statewide postponed trials back in March, and they had a number of updated orders as that finish line kept moving. And then they've had some orders that deal with some specific changes from court rule regarding some family and juvenile court matters, how to have, whether you can release some of the deadlines that are in some of the rules and make things a little more flexible so courts could deal with doing Zoom hearings, for example. They've relaxed some personal appearance kind of things that they can, Supreme Court can change local rules kind of with a stroke of a pen, and they've done that on a couple of these things. But at least with respect to a potential renewed decision to postpone trials, they decided that they were going to kind of leave it to the local jurisdictions.
Okay, and this question might be better suited for Pam, even and or Robin. The time is ticking on the COVID money and expenditures and such. And I'm going to presume that you've expended everything that you have, or you have been allotted. But should more money come, do you have kind of a plan in place as to how you will use that as well? So I don't know if Pam or Robin want to take that. Or neither. That's fine then.
The answer is yes. We still have ongoing lease expenses and court security officers at the location. And also we just recently purchased some additional laptops. So we do have ongoing costs that we're utilizing CARES Act money with from AOC.
Yeah, we're hearing more rattling in the news though about a potential, some type of a, somewhere between 500 billion and $2 trillion as a relief fund being approved somewhere in there. Robin, you were going to say something.
So as Pam said, we'll have ongoing costs of the court, mainly to run the offsite courtrooms. But in addition to that, we'll have public health expenses, the ongoing costs of some of the software that we've purchased, the just the costs of PPE and
Hey,
other
Robin.
things to.
Hey, Robin. Gary, we can hear you. Please mute your phone. I'll come to you next. Thank you. Go ahead, Robin.
So just things to keep both the public and our employees safe. We're thinking about what our employees need in terms of leave time, just a lot of issues as we go forward. So if we do see more money from the federal government or the state, we know what types of things come to immediate mind on how to spend it.
And the new system that we have coming in for customer service, where you take a number and go sit in your car, or they call you, whatever, is that for court as well, or no? Oh, it is.
We did order that software for the courts.
Oh, good.
Got to get it functional.
Got it. Okay, it's not up yet. Okay, good. Commissioner Edwards, you're on the phone. Go ahead, sir, if you have anything for Judge Price or Pam Hartman-Beyer.
Oh, okay. Now can you hear me?
Yes, we have been. Sure, go ahead.
Well, I'm not sure that was me because I was on mute. So anyway, no, I really don't. I'm sorry I got here a little late. Robin is listening in, and she's going to fill me in on anything that I missed. So no, go ahead. I'm sorry for that confusion.
Nope, not a problem. Okay, anything else, Ty?
Nope, none on that.
Yes, I have done. Pamela?
Mine is probably more a question for Ramiro, who's not here, but in regards to the ninth judge request, if that is accepted and funded, we do need to reach out to the local legislatures. And normally that's something that the commissioners like to do. So I'll just send out an email to Ramiro, so that's on his list, but I just wanted to let you know that as well.
Yeah, I wouldn't think that'd be an issue, but okay, that's good scoop to have. Judge Eric Price, do you have anything, sir, before we close out?
No,
Okay, Robin, anything? Okay, Gary, we're just about ready to adjourn this meeting. Do you have anything to add, sir?
No, sir. No, I do not. Thank you.
All right, well, then this meeting, Superior Court Update is adjourned. Thank you all, and be safe and happy holidays. Stay warm.